Prachi Pratap. Today we will discuss about cruelty as a ground for divorce. The court has to deal not with an ideal husband and an ideal wife, assuming any such exist, but with the particular man and woman before it. The ideal couple or a near ideal one will probably have no occasion to go to a matrimonial court for. Even if they may not be able to drown their differences, their ideal attitudes may help them overlook or gloss over mutual faults and failures. Lord Reed said this in Collins v. Collins in 1963. The same was quoted by Supreme Court in Dastani v. Dastani 1975. The amendment to sections 10 and 13 of Hindu Marriage Act 1955 made cruelty simpliciter a ground for judicial separation and for divorce. The provision is not just restricted to women but extend to men as well. Cruelty. Cruelty is generally considered as of two types: physical cruelty and mental cruelty. Mental cruelty is not mentioned anywhere. It is always left at the discretion of the courts, which depend on the facts and circumstances of every case. In the landmark judgment of Maya Devi versus Jagdish Prasad in 2007, the Honorable Supreme Court held that their spouse can apply for divorce on grounds of any kind of mental cruelty faced. In this case, the husband was granted divorce on the grounds of repeated cruelty by his wife. Yet let's look at the other side of cruelty. It is often noticed that cruelty is abused in divorce applications, and sometimes reality is amplified with wrong motives. In Swati versus Arvind Mudgal 2015, the court held that in order to constitute physical cruelty, one or two acts are more than sufficient, even if the single act may be so grave and weighty that it could satisfy the test of cruelty. It amounts to physical cruelty. It was also held that false accusation of stealing gold and cash was also found as an act of cruelty and ground for granting divorce. It was also maintained that leveling serious false, scandalous and defamatory accusations constitute to treating the spouse with cruelty. In Jayadayal versus Shakuntala Devi, the court had said that making a false allegation of physical and mental torture against husband amounts to mental cruelty. Making false allegations about the character of the other party is also cruelty. Now, attempts to commit suicide is also cruelty. It was held in Harbhajan Singh, Monga versus Amarjit Kaur. The Madhya Pradesh High Court held that the threats of committing suicide by one spouse constitutes cruelty to other. Thus, it is valid legal ground to seek divorce. In this case, the wife would often threaten to commit suicide. I'm often asked if defamation amounts to cruelty and a ground for divorce. In case of Joydeep Majumdar versus Bharati Jaiswal Majumdar 2021, where the wife had marred the reputation of husband by defamatory complaints to husband's superiors in army, which led to a court inquiry held by the army authorities against the husband. His reputation was damaged and career progress suffered. Honorable Supreme Court held when the reputation of the spouse is sullied amongst his colleagues, his superiors, and the society at large, it would be difficult to expect condonation of such conduct by the affected party. The Honorable Supreme Court also held that the High Court was in error in describing the broken relationship as normal wear and tear of middle-class married life. The marriage was dissolved. Suggested that defamation is regularly disrupting and insulting the spouse in front of society, which causes pain and mental agony to the other would amount to mental cruelty. In the case of Vishwanath, son of Sitaram Agarwal, and Sarla Vishwanath Agarwal 2012, the court held that the motive was to demonize the reputation of the husband in the society by naming him as a drunk, womanizer and a man of bad habit. This constitutes mental cruelty, and this conduct of the wife has frozen the emotions and snuffed out the bright candle of feeling of the husband. Thus, it is clear that with this mental agony, pain and suffering, the husband would not be able to live with the wife, therefore entitled to decree of divorce. Let's discuss another interesting case where the wife had filed for divorce. The husband said that since the wife was working abroad, it amounted to cruelty. And the court court had to decide whether a wife pursuing her career amounts to cruelty. So, in this case of Prakash Chandra Joshi versus Kuntal Prakash Chandra Joshi, 2021, a divorce petition was filed by appellant husband under section 13(1)(a) and 31(b), which is cruelty and dissertation of the Hindu Marriage Act 1955. It was stated that the respondent wife had deserted the husband and inflicted cruelty. The appellant had lost his job due to recession in 2010 in Canada. Then both parties moved to India. Later responded, the wife went back to Canada. The appellant said that respondent did not reply to any of his email. The same was not corroborated with evidence. Both appellant and respondent have dual citizenship, but appellant only traveled to Canada only twice in this period. Both had mutually agreed to immigrate to Canada. However, it was the husband's idea who later sponsored respondent's spouse visa. The Honorable High Court of Judicature at Bombay held that it was the appellant who had first consciously decided to settle in a foreign country. As such, the wish of the respondent cannot be branded as an act of selfishness, or the act on her part cannot be said to be unjustified. It is pertinent to note that it was the appellant's initiative and desire to immigrate to Canada for better prospects. Thus, in no way it could be said to be cruelty meted out to the appellant by deserting her spouse. So the key takeaway is that a wife staying abroad for her career is neither cruelty nor desertion of spouse. It is a much laudable judgment for women who often have to sacrifice their careers in order to make their marriages work. Referring to judgment by Honorable Supreme Court of India in Samar Ghosh versus Jaya Ghosh 2007, the court maintained that it would be very difficult to constitute that the marriage of the parties has deteriorated to such an extent that it would be impossible to unite the couple, especially with a young child. The court held the married life should be reviewed as a whole, and a few isolated instances over a period of years will not amount to cruelty. The ill conduct must be persistent for a fairly lengthy period, where the relationship has deteriorated to an extent that because of the acts and behavior of a spouse, the wronged party finds it extremely difficult to live with the other party any longer, and that may amount to mental cruelty. The courts respect the fine line between attempts to save the matrimonial ties and false allegations of cruelty to blotch the reputation of an individual to seek divorce. Hence, both spouses are entitled to seek divorce on account of cruelty, yet misuse of cruelty as a ground is not as easy as it may theoretically appear, reiterated in recent judgment. The courts are both progressive and discerning in their approach to decide cruelty as a ground for divorce. I hope this video was helpful. Let me know in your comments. Thank you.